This is going to be so great. Well, maybe we just get started. I think we'll have some stragglers coming in for sure, since it's just right at 7. But let me just introduce myself. My name's Shannon Poppleton, realtor with Return Properties. My husband, Ethan, is the little return symbol at the top. He is the tech guy tonight. So any of the issues that anybody's having, just raise your hand and he'll be back there fixing those. So this year we started something new. Offering just education seminars, anything to do with real estate, anything that would help you potentially in your life. So our first one was last month, and we did a first-time home buyer webinar, and we're learning as we go. So we had a few hiccups on that one. This one is our next one, and we have Chris Guymon here. He is an attorney here in Cache Valley, and we're going to be talking all things wills and estates, and I'll introduce him here in a second. We have, I don't know if Catherine is on. I haven't seen Catherine on yet. She is an agent on our team.
Yep.
Did you see her?
Yep, she's on now. I can see her.
Beautiful, beautiful. Catherine, if you have ability to turn on your camera and say hello, please say hello. She is an agent here in the Valley as well. Vicki Tripp is on. She is also an agent on our team. And Vicki, you're welcome to say hello as well.
Hi. It didn't give me an option to show my camera, so I'm not sure how to do that.
Yeah, that's okay. So Ethan's in the background. He is looking at kind of our settings to see if we can switch that mid-call. So we'll keep an eye on that, and hopefully we can fix that for you.
Perfect.
Okay, and now, so let me introduce Christopher Guymon. I'm actually going to pull this up because in a minute I am.
You're making me miss my hair on that picture, though.
Is this a recent style?
Yeah, now I see the hair. I'm like, man, maybe I need to grow it back out.
I think it looks great. Okay, it's disappeared. No, it isn't. Here we are. All right, Mr. Chris. Chris Guymon is a local estate planning attorney. He's the founder of the Conflict Resolution Center, a law firm dedicated to safeguarding families' futures. Their primary focus is coming up with creative ways to provide the fastest, best, and most affordable solutions to your legal problems. When he's not working, he likes to spend time with his family, play outdoors, and travel, which we've heard that he has been traveling. I don't know if it was for fun or not, but
yep.
Both. Okay. He likes to read, especially fantasy books, and self-help or negotiation books, which I'm not surprised. So I met Chris several years ago, and he was practicing as a realtor as well, back at Cornerstone Real Estate. So it's so great to see him again. Great to have him on so that he can educate us and get help us get our affairs in order. So just before we get going further with him and turn the time to him, please in the chat, if you're having problems with anything on here, hearing us, not being able to ask a question, please just let me know. You can call me or text me even on my line, because I've got my phone right here too. But interrupt anytime. And I think, Chris, would you agree? Like if something's confusing you or you're not understanding, this is very interactive. So please ask questions like pertinent to your understanding. So if we get too far down a rabbit hole where it may not apply to majority of people, then we'll probably guide you to just set up a separate call with him to go over very specific details. But for here, like general questions, not understanding, please ask.
Yeah, it won't hurt my feelings if you interrupt me and ask a question. So feel free to talk or put it in the chat if that's easier for you.
Right. If you don't want your voice on, we understand, but it's not scary. We're not scary people. So anyway, without wasting any more time, let's turn it over to Chris and hear what he has to share.
Yeah, I mean, thanks for having me. I love doing this stuff, and I'm pretty passionate about estate planning when it comes to kind of people like the people who are here. I'm assuming the people that are here are either own homes or are interested in owning homes. That's why you know Shannon. And I tell people that you need an estate plan if you have one of 3 things. One is if you own a home. And there's some really tricky things with home ownership when you pass away. And we'll talk about those in a second. But that's like one of the biggest ones. And I'm assuming most of the people here either own a home or want to own a home. The second one is if you have kids. You want to make sure that your kids are taken care of if something were to happen to you. And so we want to have a plan for that. And the third one is if you have a net worth of at least $250,000. And I know that sounds like a lot of money, but that includes the equity in your home and it includes your life insurance. And so anybody that has either of those probably meet that criteria, even if you can't spend it now, if something were to happen to you, that money is there. So if you have any of those three things, then you definitely want an estate plan. If you're considering any of those three things, then it's probably worth considering an estate plan as well. So I'm guessing that fits most of you. If not, though, I'm happy to talk to you about your individual situations.
Chris,
So,
before you keep going, let's do that poll to maybe see where everyone's at, if that's okay. And if everyone, while we post that poll, take a look at those questions, kind of see where you land, and then maybe raise your hand if you're in the chat box or wherever you see that little hand at the bottom, if you actually currently own or are about to own your own home. Can you see the answers coming in?
I don't see the answers coming in now. I can see the poll.
Okay. Okay. It looks pretty good. We're getting a pretty broad range of answers here. Pretty even. We'll give it a little bit longer. How many people do we have on? 12. 6 people. Maybe nobody else wants to answer or they don't apply. But it is interesting to see, so we'll give you 10 more seconds. Maybe you're just slow readers. Or thinking about the answer, because you can only pick one.
Because it doesn't let the panelists vote, so that's 6 out of 7. So that's pretty decent.
Oh yeah, we're good then. Yeah, because I tried to vote and I couldn't. So
yeah, I did too.
Ethan, if you'll go ahead and end that poll, then we can share the results so we can kind of see. There we go.
Sweet. Yeah.
Yeah, pretty good.
Except for outdated. So I love it.
Mm-hmm. Mm-hmm.
Awesome.
Yeah.
Awesome. Ethan, can you give me the next slide? Yeah. So when I'm doing estate planning, like I don't want to just sit here and like tell you what all the estate planning documents are and what they do. Like I don't feel like that adds a whole lot of value. What I like to do with these things is kind of talk about the major pitfalls, things that you want to avoid with your estate plan, or kind of some of the most common problems that people face when it comes to estate planning. The one is the do-it-yourself estate planning. The next one's issues with probate and why we want to avoid probate. And then another one's an incapacity. That's something that when I first started practicing, I didn't even think about. And I had another attorney kind of open my eyes to the expenses of incapacity. And so I wanted to go through that as well. So Ethan, if you can give me the next slide, we'll talk about the DIY estate planning next. So it's not uncommon for people to try to do their estate planning on their own. In fact, you can go on like Rocket Lawyer and create a will for like $90. It's super cheap, and because of that, like a lot of people are tempted to do that instead of pay an attorney to do their estate plan. There's some issues with that though. And the biggest issues, if the group is older, I don't know how old everyone's here, but the older people get, the more common I see this first issue. And that's they're doing estate planning and they want to make things easy, and they go and they put their kids' names on their assets, whether that's adding them to title of their house, which is less common, but the most common way of doing this is putting their kids' names on their bank accounts. And you don't have to raise your hand if you don't want to, but I can almost guarantee that there is someone here, and you can raise your hand or say it in the chat if you want to, that they've either put their kids on their bank accounts or they've been put on their parents' bank accounts at one point or another. And if so, and you're willing to admit it, put it in the chat or say something to the group here, because I want to know if any of you have had that before.
So you're asking if any of us are on our parents' accounts or we've put our kids on our accounts.
Yes.
I am on an account.
I knew it. I've never done one of these presentations where someone hasn't raised their hand. The last one I did, thought about it. Bill thought about it. Good.
So,
The last one, it was like 80% of the room raised their hand, and and I just laughed. So, like bank accounts specifically, if when someone passes away on a bank account, the bank just erases that name from the list. And so, if like you're on the account with your parents, Shannon, and your parents were to pass away, that money's yours. And that, which is fine if you want the money, right? And that's fine if that's what you want to have happen with the account. But more often than not, what parents want is to give money to their kids in relatively equal shares, right? And so I had a case where this happened one time where they had $100,000 in their savings account. And so their total net worth was about $300,000, and they had 4 kids. And so I should have done the math. I should have made the numbers balance out instead of just making those numbers up. But normally, if you have 300,000 and you have 4 kids, they want each kid to have about 75,000. Well, what happened here is because their one daughter was on the bank account, she got all $100,000 of the savings, and then the other 4,000 or the other 200,000 was split amongst the 4 kids equally. So she got 150,000, and her 3 siblings each got 50,000. And not surprisingly, they thought that was unfair. And now she tried to justify and say, I'm the one who took care of mom and dad. They wanted me to have this money. And maybe they did. Like, I don't know if they did or didn't. They never told me. But on its face, when the will and trust says, I want to give things to my kids equally, and then one kid gets 150 and everybody else gets 50, which if you do the math is 150 total, she got half and the other 3 kids split the other half equally. That doesn't come across fair. And obviously what happens there is then the 3 kids hate the one kid and they don't talk to each other. And I'm pretty sensitive to that because my dad didn't speak to any of his siblings for over 10 years from things that happened when his parents passed away. And his dad was trying to do the best he could. He had a decent amount of money and he didn't so my dad's good with his money. So he just gave my dad his share, but his twin is really bad with her money. And so he put her share in trust and made my dad the executor of her trust. So now my dad's the one who has to tell her when she can and can't spend money, which not surprisingly, no one wants their brother who's the exact same age as them, technically 2 minutes older, but the exact same age as them, telling them when they can and can't spend money, right? And so that's the kind of stuff that I'm trying to avoid here with estate planning is most people, when I talk to them, they say, I would rather burn all of my money and my kids get along than give them something and then fight. And that's, when I say protecting families, like I want to give your money, you've worked hard for this money, so you should 1, spend it if you can. But 2, if there's something left over, it should go to your kids. Like we don't want to just burn it or give it to the government, but not at the expense of those relationships, right? So that's the biggest thing. Like if you get nothing else out of this whole call, I hope you get that you don't want to put your kids' names on your assets because there's lots of complications with that. If nothing else, even if there's not something crazy, anything that your kid's name is on is subject to litigation later. And there was a case where a gal hit a minivan full of kids, and it was a horrible situation, but they all died. And we never want to see that. But the liability on that was astronomical. We're talking tens of millions of dollars. And it was no fault. It wasn't like she did anything intentionally wrong. But when people pass away, obviously, there needs to be some compensation for that. This person didn't have money. But as the lawyers were going through things, they noticed that her name was on title of a piece of real property, and she was on title of her parents' home. And so when this case settled, not settled, but resolved in court, the attorney went and took the parents' home as satisfaction of this claim. And again, it wasn't vindictive. Sometimes these things are vindictive. Like I've seen kids go in and drain their parents' bank accounts, and I get to say that that's what kids are going to do because I get to play devil's advocate. But you can assume that your kids will never do that. But even if there's not something vindictive, it's a very likely possibility that one of your children will become subject to litigation at one point. If nothing else, the example I give is that it's like 1 in 3 Americans right now get cancer. And cancer can run up $100,000 bills easily. And we just don't want your stuff being paid for something like that, right? And so do not put your kids' names on your assets. Yeah, Shannon.
Yeah, so these are great. I love like real examples, and I think instilling a little bit of fear is a really good idea.
Yeah.
But rest assured, you're going to tell us what we should do instead of putting our kids'
Absolutely.
names on our assets.
Absolutely.
Okay.
Absolutely. I always like to give the horror stories first so that people listen to the why, what, how to fix all of this stuff. Absolutely.
Right.
And yeah, we talked about the joint owners on real property, beneficiaries of investment accounts. The only thing there is like with life insurance, those types of things, you can put a beneficiary for those. And it's very common. You have to. Generally, what we want you to do is put your estate plan as the beneficiary. And that way everything goes into one pot and then that pot gets divided how you wanted it. And you can do equal shares. You can give one kid more. I don't care what you do. We just want to make sure everything gets compiled and it's divided fairly. If not, like if you put different beneficiaries on different accounts, then sometimes those accounts can vary in amounts over the years and you end up getting an uneven distribution later. So that's really the DIY estate planning things to avoid there. Let's go to the next one if we can, Ethan. So the next thing that we're trying to avoid with estate planning is probate. So for those who don't know, probate is the court action to divide someone's estate when they pass away. And historically, that's how we did estate planning. Everybody did a will, and then when you passed away, you did a list of all of your stuff, you took it to the judge, and the judge made sure that your stuff was given to the people that you wanted it to go to. Court used to be significantly simpler. Things would go in and they would go out really quick. That's just sadly not the nature of court systems now. I have seen court cases where the attorneys were paid over half of the estate. It was so much work and people were fighting that over half of the value of the estate went to the attorneys, and then the other half was divided amongst the kids equally. And we just don't want that to happen. I mean, if you're worked this hard for your money, we want it to go to your kids and not to my kids. Okay, my money can go to my kids. Your money gets to go to your kids. And so another issue with the probate is just sometimes you have to fire sell assets. So when I was a real estate agent, I'm not anymore. Shannon and Ethan are much better at that than I am. And I figured that people who are doing this full time should be the ones that are doing it. And I'll stick to what I'm good at. But when I was an attorney, really all I would ever do were real property that was tied up in litigation, like the niche right there. And I had a couple of cases where someone would pass away. They had a home, they had a mortgage on their home, but because they didn't have a trust, we couldn't use their bank account money. Their bank account money was frozen to pay their mortgage. And so their mortgage was going unpaid. And not surprisingly, the mortgage lender wants to get paid. So they are moving forward with a foreclosure process. And in this case specifically, they had over $100,000 in their savings. So had they had a proper estate plan, we could have just used that to pay their $1,500 a month mortgage, and nothing, we would have had 100 months to figure it out. But because they didn't have a proper estate plan, we had to fire sell their home as quickly as possible so that they didn't lose everything. And they probably lost about 40,000 in equity because of having to sell it so quickly. This was pre the crazy inflation, and so not as many cash buyers as we have now. Yeah, Shannon.
So for example, when you're saying they didn't have an estate, so you're just saying like they own their home, it was just in their name, they passed away, and that's a problem.
Yeah, 75 years old and didn't have even a will. Even if you had just a will and no trust, you'd run into the same issue. Probate is how you give people's property away if you don't have anything written or if you just have a will. And so yeah, it's problematic in that situation, right? If all of the kids get along, sometimes it's not as drastic as that. But if any of the kids say, hey, that's not what should happen, the court locks everything and says, we're not touching it until we can have a hearing on it, which is usually 1 to 2 years out. And I have seen homes sold in foreclosure when there was money in the bank account, but the court wouldn't let them use the money. And so that's why I say if you have a home, you've got to have a real estate plan. Like I'm going to tell you what a real estate plan is and how to do it right. But especially if you have a home, you've got to. So Brent, you have a question. I see your hand raised. And you can just type it out or you can unmute yourself.
Yeah, go ahead and unmute if you're okay with that.
Okay, sorry. It's just easier to ask it than type it.
No, I would say the same thing. I love that.
I have a friend who she did an estate, because they have quite a bit of assets anyway.
Yes.
But she said that when the lawyer did her estate planning, that they had to put their house in the lawyer's name. I don't know if it was just during the transition or to manage the estate. I don't know, but she said that it had to be placed in his name, and I don't know if it was temporary. Does that make any sense to you at all?
It does not, no. And I'd be happy to meet with your friend to look over that and make sure that it's correct, because that has a lot of red flags. Attorneys should not be taking your assets and putting them in their own names. I have had an instance where a court, like we sold a home and the court put the proceeds of that home in my trust account. So that's not my money. It's a bank account that I have control of and the Utah Bar has control of. So the money went into that account until the court could determine who got the money. So things like that are happening, but that's still not my money, right? That's accounted for. If I can't account for every penny of it, I get disbarred. So it's a kind of a very high burden of proof. But to put it into my own name, that's a lot of red flags. I would definitely want to look at that.
Okay, well, I mean, it was years ago, and that's her deal. I just
Yeah.
remember when she told me, it just did not sound kosher. So
No, definitely not. No, you shouldn't be giving things to your attorney for sure. But you would probably put it in the trust. Normally we would put it in the trust name.
right,
I'm
right.
spoiling the answers to all of these problems with have a trust, but absolutely. That's a good question.
Okay, all right. Thank you.
Yeah, you bet. So, I mean, I have a list of all the costs of probate there, but all you need to know is that probate can get very expensive. We don't need to get into the details of that. Let's go to the next slide. The other big expense, if you don't have a proper estate plan, is what we call incapacity. So if there's a period of time in which you're alive, but you can't take care of yourself, that's what we mean by incapacity. And this can be different for everybody. So like my grandma, she had Alzheimer's. And so for a couple of years, like it was funny, like, you know, she'd forget silly things, but like she was still there. When she moved into her house with my grandpa was super all there, but like we were moving them into their house and she sat on the couch with my dad, her son. And he's like, you know, what do you want to do? And she's like, oh, just sit here and flirt. Because she didn't like, as she forgot her things, she would think she was younger than she really was. So she saw herself as a 40-year-old single person, and which made my dad the perfect suitor. And then for the last like 10 years of her life, or 5 years of her life, like she wasn't even verbal. And the very last thing she ever said, funny enough, I was leaving on my mission, so I went to say goodbye before I left, and I'm talking to her. She's not saying anything back. She sits up in her bed and says, "Ah, hell." And she never swore. So it was really funny. And I think that's the last thing she ever said was, "Ah, hell." So she needed help for at least 10 years of her life. Like there was no way she could pay bills or anything like that. My grandpa was sharp as a tack, so he is the one who did all of those things for her. But especially if my grandpa hadn't been there, like we would have needed to set somebody up who could take care of her, right? That's what incapacity is. And for other people, it can be a blip. Like my grandpa, or I should say, my grandma passed away. They did her funeral, and then 4 days later, my grandpa passed away. And when he didn't come down for breakfast that morning, the people at the nursing home went up to check on him, and he had passed away in his sleep. But they walk in, and the table next to the door, there was a binder on the table, and he had written his son's funeral talk. He had called the funeral home and scheduled the funeral for that Saturday. Like he did everything. And they walk in and the binder's like set up with everything. So he didn't need a blip of help. Yeah, it was kind of eerie how he knew it was his time and he scheduled everything and then went to bed and didn't wake up. So, and yeah, Shannon.
So like this is all so good, but I think when we all get to this point, and I think a lot of people on here are probably currently helping family or have helped parents or whatever. At what point does this get talked about? Like when do you recommend that like you sit down with your children or your parents and you say like, hey, we really need to talk about this, because you really never know. Like they could be in a car accident and then and not be able to function. And then what do you do? Because they don't have a say.
Right. And that's the scary part about incapacity is if you set it up now, it's really easy to set up and it doesn't cost very much. If you don't set it up now and something happens, then you have to do it through the court system, and you're a minimum of $1,500 to $2,500 to set it up. And then you pay between $500 and $1,000 a year to maintain it. Because every single year you have to go in front of the judge and show that you've managed their money properly, that you're taking care of them, all of those types of things.
So
Sometimes
these
you can push that
aren't
out
here.
for multiple years, but it's incredibly expensive to do a guardianship and conservatorship through the courts if you didn't set it up before. So to answer your question, when, today is the right answer. When most people do is when something happens, right? Like something will happen to their parents and they go, wow, I don't want that to happen. Like, I don't want to do to my kids what I had to do for my parents. And then they set it up. The other time is when people have babies. Then they start thinking about their family and they actually want to do something about it. So I found that to be a really good trigger. And that's the scary thing here. And it's why I talk about these pitfalls first, is because over 50% of Americans pass away without an estate plan because it's not urgent, right? It's super important, and you guys can see that it's important, but there's always something else that can be done. And so because it's not urgent, we forget about it until it's too late. Yeah, Brent, I see your hand raised.
So you're saying put as a guardianship in your estate plan, and it doesn't cost you a yearly maintenance fee or any other setup fees that's written into your estate plan?
Correct. Yep. We'll talk about how to do those here in just like 5 seconds, but yes, that the short answer is yes. If you
Okay.
have, they're called powers of attorney, but if you have a powers of attorney set up in your estate plan, then you
Okay, yeah.
guardianship.
DOA, all right. So you can have more than one guardian. You can have split guardianship, conservatorship.
Correct. Yeah. Technically, a guardianship is who takes care of you. Like if you need instructions to the doctors or something like that. And a conservatorship is who takes care of your money. Often that's the same person, but legally they have two separate names.
Okay. All right. Thank you.
Good question. Like I said, I love questions, so please ask. So I think I've instilled enough fear that you're going to at least think about estate planning, right? So let's talk about what a real estate plan is and how they work. If you can give me the next slide. Perfect. So I kind of wanted to just give you a quick list of all these things. There's not a test later. You don't have to remember what these things are, but there's a list of documents, a group of documents that I consider you need to have in every single good estate plan. The first being a trust and a will. And we'll talk about each of these in a little bit and how they work, right? But like, I want you to have a will and a trust. And then you need to put those things into your trust, and that's called funding. And we'll talk about that as well. There's some helpful documents in there, and then there's some power of attorneys. Powers of attorney for your healthcare, for your stuff, and then there's a document called a living will, which is instructions to the doctor. And we're going to go through each of those, but I just want you to kind of see that. What I don't want you to do is go on Rocket Lawyer and go create a will. That's one document, and it is a helpful document that does some good things, but it doesn't do everything that you need. So if you want to truly take care of your legacy, you need all of these things. So if you give me the next slide. Perfect. So revocable living trust, why not just a will? The trust avoids probate. That's the shortest answer here. Anything that has been properly put into your trust doesn't have to go through the court system. And so, especially like if you have real property, like we talked, if you put it in your trust, then, and you have your bank account in your trust, then if something happens to you, especially when there's a mortgage, we can use the money in your bank account to pay the mortgage or pay your utilities or pay a cleaning company to remove the stuff out of there, whatever those things are. We have an asset and it's put there. It also makes it significantly easier on the sale side because you don't have to go through a court system to get the court's approval. We just have to have proof of death. We have proof of who the new trustee is, and that new trustee can then handle the real estate transaction if a sale makes sense. The trustee also has a lot of control here. So if the market's high, like right now, the market's really high. So if you bought a home 20 years ago, I guarantee it's worth a lot more now than it was. Yeah, Shannon's giving thumbs up. You have a nice nest egg right there, right? But say like you bought your home in 2006 and now it's 2008 and your home's worth 40% less than it was, the 2 years before. The trustee has power there to decide what to do. And so even 10 years ago, you were golden. You're absolutely right, Shannon. So if the market was down and you're upside down on the home, the trustee doesn't have to sell it. They could rent it out for a couple of years, see what happens. Like they have the leeway there to take care of your assets. And so and I can't stress that enough. If you have to sell through the court's going to make you sell it in 90 days. They don't care if the market's up. They don't care if the market's down. They just want your case off of their docket because they have a bunch of cases on their docket. Or if you have a trust, you have the flexibility to do what's best for that. You could also do things like have one of your kids purchase it and take those proceeds and give it to the other kids or something, right? And they can, there's a lot of flexibility there that the trust gives you. So even if you don't have a large estate, if you have kids, real property, or 250,000 or more, I definitely encourage getting a trust. Especially with kids, you don't want to be giving young kids money. We want to make sure that that's used properly. And so with a trust, their money would stay in the trust until whatever age you pick is appropriate. Some people do 18, some people do 21, and some people do 25. Those seem to be the most common ones. Often what we'll do is we'll say until the youngest turns a certain age. So we'll leave the money in there. We'll use the money to pay for college. Some do 36. Yeah. Well, you do to pay for college, whatever, missions, if people want to do missions, whatever, right? You put a list of what the proceeds can be used for. And then after all of those things have been paid for and your kids are set up, then whatever's left over, you spread to them equally and they can use to buy their first home or something. But it gives you that flexibility that you can't do with just a will. Did you have another question, Shannon? Yeah.
Going back to that 250,000. So you were saying the 3 reasons: kids, real property, and 250,000. It's not all 3. Is it just one?
Just one. Just one of those. Absolutely.
Okay. And then somewhere, and so I guess that makes my other question irrelevant, but somewhere I was reading, they were saying if you have $100,000 worth of equity or assets, that it's worth it even still to do it.
Definitely. And I've seen things as little as $10,000. I'm pretty conservative in my advice to people, and I want to make sure that it's always worth it to them. But yeah, you could definitely do it. Especially young families. I know a lot of young families are like, I don't want to do this right now. Like I'm young, I'm healthy. And I still have them do it. You just never know what's going to happen. My cousin, he's 33 years old, just had a stroke and can't work. And they needed that power of attorney when he was in the hospital. So you just never know. I mean, he was healthy, like 6-pack, could touch the rim on a basketball hoop, police officer, healthy as can be. You would have never thought that he would have a stroke, you just never know. So, but at a minimum, if you have any of those 3 things, you definitely need a trust. If you have less than that, then you may be able to get away with a will. But if you have less than $50,000, you probably can get away with a will because there's what's called a simple probate of everything less than $50,000. But definitely once you've crossed 50 or more, it's worth considering.
And then is this, thank you for that clarification. Is this across all states? So if I have something in Utah or something in Arizona, or if I move, does this apply or does it need to be reassessed in every state that you're in?
Yes, it applies to all 50 states. I'm only allowed to give legal advice in Utah, but the state plans that I draft should work in all 50 states. They have to recognize things from other states, so they should work straight up. But we've also gone in and set them up in such a way that they should just straight up work in every state without the full faith and credit clause. Yes. So yeah, everything's going to work. You get to Louisiana and some of those things are a little different there than here. But other than Louisiana, 100%, I feel confident in the 49 other states. But yes, it would work in Louisiana as well. So good question. The next question I always get after people get sold on trust, they say, well, then why do I need a will? And 2 reasons. One is we can't sell children. And that sounds funny, but their contracts for children are obviously not allowed. And a trust is a contract. So we have to, if you have minor children, we have to have a way of picking the guardian for your minor children. And that really is the law behind it, but that's the biggest one. The other thing is, for a trust to work, you have to put things in the trust. We call that funding, and you can see that's the next thing on the list. If something doesn't get put into the trust properly, the will captures that and puts it into the trust. Now, it still goes through probate. Yes, it still goes through probate, but at least it gets to the right place at the right time. So the will is kind of a safety net. Originally, we used to call these pour over wills and pot trusts, and you'd have like a little flower, whatever thing. Then marijuana became legal, and they told us to stop calling them pot trusts. And so they still call them pour over wills, funny enough, but they don't call them pot trusts anymore. I call them an empty vessel because I don't know what else to say. But that's really the thing there. So Bill asked, does a trust protect your house? So yes, a trust protects your house. I'm not sure what so is, Bill, if you want to give me updates on that. The trust does absolutely protect the home. That's like one of the biggest things. It also protects it from probate. It was the other thing there. If you want to give me a follow-up question, does a trust protect? Oh, yes.
We're getting closer. We're getting closer. Bill, you can
And
unmute.
you can totally just unmute yourself, Bill, if you want. While you're asking that question, I'll just go through funding real quick.
Okay.
So this phrase, I don't know why they call it funding. It doesn't make sense to me. But funding is the action of putting your stuff in the trust. So some of the lists on that document, like the certificate of trust and those types of things, make it easier to do that. But one of the questions I get is like, what happens if you don't put things in your trust properly? And that's why we have the pour over will, is to protect it. It's not foolproof. Like, there are some things that have issues with it, but funding is really easy to do. What I like to talk about when it comes to funding is just kind of a thing to pay attention when you're deciding what type of attorney to hire. Is there are two different thought processes amongst attorneys. One is they will do all of this for you, and the other is they will let you do it yourself. So you can, in your trust, like literally list every single piece of property, and anytime you have a change, you have to then amend your trust to make sure that it's taken care of. And like with like a house, like we would do that, and just because it's listed in the trust doesn't actually put it in the trust. And then we would have to go to the title company and have them like put it in the trust, or the attorney can do it for you, but don't let attorneys do that for you. The title company will do it for like a fraction of the cost. And I've never seen a title company get it wrong. I have seen attorneys get it wrong lots of times. Title companies are good at title work, and so let them do it. The other thought process is let the people do it themselves. So you create this empty vessel of a trust, and then you give them instructions on how to put things in, and you can like walk them through and make sure that things get put in there the right way. But at the end of the day, you let them do it. And that's the way I do it for a couple of reasons. One is you don't have to pay me to make changes. If you sell your house and buy another house, as long as you title it properly, it doesn't cost anything on the attorney side. The other reason is most institutions won't let me touch your money. So not surprisingly, if I go to your bank and say, I want to take money out of your bank account and put it into another bank account, they won't let me do that. And so the attorneys are like doing powers of attorney and all these crazy things to be able to do this for you, which they're charging you for. And it ends up just being significant amounts of work for something you could have done for 10 minutes and saved thousands of dollars. The average estate plan, when the attorney is doing it for you, starts at $5,000 and goes up from there, like $10,000, $20,000, $30,000. I did one that we were already over $50,000 into it by the time I was helping. It was before I was an attorney, so I was just helping another attorney do it. But we're talking massive amounts of money. Where if I let you do it, then it's between like 1 and 5,000. Like, it's just significantly less. So that's one of the things when you're looking at attorneys, paying attention to that, because you don't have to spend $5,000, $10,000, $20,000 for an estate plan if you're willing to do a little bit of the legwork yourself. Now I see your hands raised, Bill, so I'm going to come back to you and see if you are ready to ask that question.
Can you hear me?
Yep, perfect.
Okay, my question is that you put a house in a trust does that help to protect it from these people that try to steal houses by falsifying documents and stuff?
Yes. Yeah, I mean, yeah. The short answer would be yes. With a trust document, you have to kind of have proof of the trust in order to pull it out of the trust. And so they, like, a title company would not be able to transfer title out of that trust very easily without at least proof of that trust. And so without proof of a trust, now they could falsify a trust as well, right? And enough work, and I'm sure they could get through it, but it would be an extra layer of protection on that. That's not really what it's designed for, but it would inevitably help with that.
Mhm. And I think there's one thing I think he's maybe referencing, and I don't know if you've seen it, but we've seen it here in Cache Valley, particularly in regards to land. So a lot of times people own land and don't live here. And so
Mhm.
they'll call a realtor and say, hey, I want to sell my land. And unless the agent like verifies their identity through the title company and through other means, like they could actually fully complete a transaction and sell someone else's land. And then
Oh,
it
really?
could be 5 years before the actual owners know that their land got sold fraudulently.
Yeah. Yeah,
So,
that would be helpful because the title company is going to ask for a copy of your trust. That's their preferred method of verifying a trust. We actually have a certificate of trust in the document. You can see it on there on the slide, that second bullet point there, which is the only thing the title company has to have, but they would have to have at least that certificate of trust to prove that the trust owns the property before they could transfer it. I'll see this with agents all the time where like a parent will pass away and the agent, like a kid calls and says, hey, my mom passed away, I want to sell the house. And the agent's like, okay. And I've seen them listed. And then we get on there and find out that kid's not the one, that's not the trustee of the home. And we literally have a home under contract and the seller is not one of the parties. Yeah. I had a
so
very panic. I'm
important.
not going to say which, it's not Cornerstone, but there was a broker that was calling me in a panic, wondering what to do because they had a house under contract and did not have a signed representation agreement with the owner of the home. So,
And Bill,
but
also
it
for
couldn't
bills
be sold.
protection too. Oh, yeah, for bills protection. Like a
Yeah.
lot of times agents will just assume everyone's telling them who needs to be on it. And we had one not very long ago where there was a dispute among the siblings and we needed signatures from all 3 of them. And the
Yep.
sisters wouldn't sign and the brother wanted it sold and it couldn't happen. It couldn't happen until we had, permission from all parties. And so it's helpful, I think, sometimes when you have multiple signers that need to agree.
Yep, absolutely. No, absolutely. And the trust weeds that out early. I mean, that's what happened, right? Now, this brokerage is not one of the better brokerages in town, which is how it got that far. But normally, a good agent or a title company would have, that's what happened. The title company caught this and said, hey, I need a certificate of trust. And they didn't have one. And when they finally got a copy of the trust, they realized that the sibling that was selling this home didn't have authority to do so. But it did stop that sale because it was caught. So yeah, it's a good question, Bill. I hadn't really thought of it that way, but it's a good question. Good. So that's funding. Let's go to the next slide. And that's really the trust, right? So that's really how you give your stuff to people when you pass away. That's the legacy part that we talked about. The other part that we talked about is kind of protecting you when you need help and however long that is. And that's that durable power of attorney. So a durable power of attorney or a general durable power of attorney is what allows the person you pick to use your money for your benefit. So it doesn't make them have to spend their money to pay your medical bills, and they can't use your money to pay their bills. It's just your money for your benefit. The next slide, I won't go to it, but is the living will where they get to tell the doctors what to do. What this doesn't do is, and the only thing it doesn't work for is real property. You have to have a very specific power of attorney for real property. The exception to that rule being real property that's in a trust. And Cody Peterson, he's over at Advanced Title. When I showed him how we did this with the home, so that the home is in the trust and the successor trustee is the same person as the durable power of attorney, And that successor trustee kicks in if you're incapacitated, not just when you pass away, but when you're incapacitated as well. Cody was geeking out. He's like, you've beat the specific power of attorney rule that is like the bane of his existence. Is by having it set up that way, we can have that trustee kick in to place when needed and be able to take care of you. Like if you had Alzheimer's, right? Like if you had Alzheimer's and you're in a care facility for 10, 20 years, we may need to sell your home to pay that care facility. And the problem is if you have Alzheimer's, you can't sign a contract to sell your home and it becomes a problem, right? Well, how we draft this estate plan, that would work. Your child would become your successor trustee. They could sell it through the trust without needing this power of attorney and you'd be taken care of. So a little loophole there that was really fun. Yeah, Shannon. You're muted.
That's amazing.
Yeah.
So very nice work. What if you run into, like, you have everything set up, they've got it right. What if the parent that is incapacitated doesn't think they are?
So the only way to be determined incapacitated from a legal standpoint is to have a doctor say it.
Okay.
And so, like, if I think you're incapacitated and you don't think so, like, I can't just, it doesn't spring into place until a doctor has said so. Some trusts you can even go in and say 2 doctors. I haven't found that to be beneficial. Like, let's just get 1 doctor that does a good job. But it does have to be decided by a doctor. Now, when it comes to like the trustee or your durable power of attorney, like using your money, that's got to be something that's decided by a doctor. These other powers of attorney, they're called springing powers of attorney, which means they spring into place when needed and they spring out of place when not needed. So like if you got in a car accident and had a coma, then it would spring into place and I'm assuming Ethan would be Shannon's power of attorney on this, right? So he would get to make the decisions and then 3 days later you come out of the coma, you get to decide what happens with your body, right? And they spring in and out of place. That can work with like short-term things like paying your bills, but things like selling your house, the court's not going to let someone spring in as a trustee and sell your house over 3 days. Like that's a little bit more complicated than that, but so it's a good question. But yeah, it only springs in and out as needed. I think that's what the next slide is. If you go to the next slide, that said springing, right? Good. Oh, good. You had the living will on there. Perfect. That's what I was hoping you had on there. Because the next one that I want to talk about is that living will. Living wills are not to be confused with standard wills, and that's why I have this as its own slide. This is the instructions for whether or not to give life-saving procedures. So the powers of attorney are ones who gets to take care of your money and use it for your benefit. The other ones who gets to make the decisions on behalf of you, like if you like to tell the doctor what to do. And the living will is kind of the instructions there of when do you want life-saving procedures and when don't you. And my number one goal with the living will is that someone doesn't live or die on a technicality. Like I want your wishes to be carried out. And my grandma, it's technically my wife's grandma, but I considered her grandma. Her husband passed away and it was like super fast. And when he passed away, the day he passed away, she signed a do not resuscitate. Not the day to be making that decision, right? She was obviously distraught that she just lost her husband. And she said, if I have the chance to die, I want to die and go see my husband again. Well, not surprisingly, 10 years later, her tune has changed. In fact, my wife was pregnant with her great grandchild, and my wife's siblings were all pregnant. All 4 of them had kids within 7 months of each other. And she is found unconscious in her house. My mother-in-law went there, found her unconscious, and obviously called 911. The paramedics show up and say, hey, we can't resuscitate her. She has a do not resuscitate. My mother-in-law then says, no, it's been destroyed. She got rid of that. So then they started looking for it. And they looked for it for about 15 minutes and couldn't find it. And the law is if you can't find it where you think it should be, then it's presumed destroyed. And if it's presumed destroyed, then you have to resuscitate her. So they resuscitated her. It was a low blood sugar issue. They literally woke her up, gave her some orange juice, and she was fine. She lived another 4 years. So she would have died had they not resuscitated her, but it was not her time to go. And in fact, after she was back to it, she's like, it's not my time to go. And she went and destroyed her do not resuscitate. It had not been destroyed. I secretly think my mother-in-law hid it. She would never admit that, and I hope she never hears me say that, but I think that's what she did because she knew better and that's not her time to go. But once grandma came to, she found it and destroyed it because she did in fact not want to die. And I just don't want that to happen. I don't want someone to be stuck on a ventilator for 10 years because of a technicality. And I don't want someone to die when orange juice would save them. In my intake questionnaire, it says, like, do you want someone, like, if orange juice will save you, do you want to be saved? And that's why it's that story specifically. So I've drafted this living will to really give as much power as possible to the person you pick. And then you have that conversation with them. I had a client that straight face said that if I can't fly fish, I want to die. And his wife said no. And I don't know if he's going to win that argument, but that's where he thinks. I've had people say, like, if I'm in a wheelchair, that's too much for me. And I've had other people in wheelchairs who are happy as can be. Like, and so it's not a right or wrong. This is between you and the people you pick. But I want you to get to say that, and not a doctor who doesn't know you saying, well, technically I have to do this. So that's where that's set up that way, is that living will. And it's super important. I don't know. A lot of attorneys screw that one up. And so I wanted to put some emphasis on that. And the last one is the HIPAA authorization. So doctors are only allowed to give information to certain people. And there are some cases, they're mostly out east and in blue states, that the power of attorney, like the person has a power of attorney and the doctor's like, yes, you get to make the decisions, but your HIPAA authorization is not sufficient. And so I can't tell you anything. So how would you like me to take care of your mother? Like, well, I don't know what's wrong, so I can't really tell you. Obviously that's not okay. The scary thing with this is even if you're legally right, things in the court take forever. And so, like, you file something with the court and often it's too late before the judge even sees it. And so this is one of the few areas in my life where I think more is more. I'm usually a less is more person. Like, I'm wearing sweatpants right now because you can only see me from the waist up, right? Like, I'm a very comfortable less is more type person. But when it comes to that emergency case of when you need help, like, more is more. I have everything that you can possibly think of to make sure that you get the help that you need. And it's put in a nice little binder that you can just hand to the doctor and say, I don't know what to do with this, but I know you will, and it will be there. So that's kind of the last one of that. I think that's kind of everything on the estate planning stuff and kind of a good summary of the stuff. Do you guys have questions on that? Like, questions about any of the things we talked about, or just estate plans in general?
Well, I always have questions.
Good. I love it.
I was trying to, oh, Catherine, go ahead.
Catherine had the question.
I have a random question just about investment properties. Is it common for people to put their investment properties into an estate, or is that something you kind of keep separate in a different kind of structure?
Yeah, super good question. You absolutely want to have your investment properties addressed in your estate plan. Generally, how we do that is usually we have like an LLC or something that's holding the investment properties. And so in the LLC's operating agreement, it will say what happens with your shares of that asset. It's usually giving it to the trust. But you absolutely want it in there. And it can be kind of tricky if not done properly. There's already a level of complexity on whether you can have loans on these things and that kind of stuff, right? And so if you pass away and it's not done right, somebody's going to get it. And that's part of estate planning. Is if you don't create a plan, you have a plan. Everybody has a plan right now. It's just the plan that the government picked for you. And if you want the government to pick your plan, then awesome, good luck. But it's usually not what people actually want to have happen. And that's what becomes tricky here, is like sometimes people will end up in business with their best friend's spouse. And they're like, hey, I definitely want to go in business with my best friend who's an expert on real estate, but I don't want to go into business with my best friend's spouse who's been a stay-at-home mom and doesn't know anything about real estate. And I'm not dissing stay-at-home moms. My wife's a stay-at-home mom, but not the person you would want to be making financial decisions about a specific topic, you know? And so, but you want to address that because you don't want your spouse to just be cut out either. Like, we want to make sure that they get their share, and you can handle all of that through, generally it's in the operating agreement, but then whatever the value of that is, whatever it ends up being, that's what gets put into the trust. So it is a little bit more complex when you're doing that. but it's definitely necessary.
Okay, awesome. Thank you.
Yeah, good question. And the stuff that we talked about today, these are like estate planning things. There are other trusts and things that you can do with assets. And like as you get a bigger net worth, once you cross, and these are for estate plans less than $5 million per person. So there's a death tax in the United States. It's currently at $5 million per person adjusted for inflation. So it's actually almost 6 million per person. Because of the inflation. I like to, again, if I tell you 5 and you come in at 5 or 10 million and you have 10 and a half, like you're still okay. Like I want to give a solid number that's easy to remember. Once you cross the 10 million per couple threshold or 5 million per person, then we're getting into some unique estate plans. And they're really fascinating. I'd talk about them for hours if you wanted to, but it doesn't apply to only 1% of Americans fit into that category. What you're doing there is you're just devaluing the property. Property is only worth what you can sell it for. And so the crazy estate plan, the $50,000 one that I was talking about earlier, they had a cabin in Bear Lake. The chandelier on the front porch was $1 million. And so a huge cabin, millions of dollars. What they did is they took that cabin, they put it in a trust that only the oldest son could buy. He could only buy it in January, and he could only buy it with cash. So they limited who could buy it, when they could buy it, and how they could buy it, right? And we were able to devalue that property by almost 50%. An appraiser came in and said it used to be worth like 15 million and now it's worth 7.5. And death tax is 50%. So instead of paying 7.5 million in taxes, they paid 3.75 million in taxes. So that it's really fascinating stuff. It doesn't apply to a lot of people, but that's why that plan was $50,000, is because we saved that person over $3 million with just that one vehicle. When it comes to investments, we can do trusts and LLCs to protect. A trust protects your asset from you, and the LLC protects you from the asset. And so if someone slips and falls at your rental house, then you would want your rental in an LLC so that they can't take your other properties. They can take the rental house, but they can't take your house or your other rental properties. If you are worth a lot of money, like Deloy Hansen, then all of his stuff is in trusts so that he can't be, if you sue him, you're only going to get a couple million, not his billion. But he has an attorney that he pays $400,000 a year to handle all of that stuff. So I tell you because I have a lot of people say like, what about this trust or what about that trust? And those are all things, but realistically, if you're south of $5 million, I'd rather just set up a revocable living trust like we talked about today, because all the other ones have such expensive maintenance fees that unless you fit into a very specific category, they're usually not worth it. People sell them though all the time. And that's why I said that kind of at the end, because I don't want you to get suckered into a $5,000 trust that you really just don't need.
Yeah. So if I understand correctly,
Yeah.
if you have multiple LLCs for different things, businesses, properties, and all of those LLCs funnel money into your trust, if you were to be sued because someone fell on your front porch, they can go after the LLC, but because it's tied to the trust, they can't go after the full trust. Is that correct?
Right. If an asset's in an LLC, then they can only go after what's in that LLC and not everything else.
But if it's in your name, they can go after the whole thing.
Right. Yep.
Did you hear that, everyone? That's a big deal.
That is a big deal. For people who are doing investment properties, you absolutely, at a minimum, want to have an LLC, right? So every single investment property I have, I'm not worth $5 million. Not yet. I would love to be one day, but I am not. So all of my stuff is in LLCs. As I get bigger and I'm like, someone may want to sue Chris Guymon because they don't like me, then I would also put them into a trust to protect my assets from me. But you know, like Deloy, he said that whole selling, I don't know if you guys know it, was a couple of years ago, but he's like said things about like selling players, and there was a huge uproar. He ended up having to sell the Real Salt Lake soccer team because of it. And people sued him directly because of the inappropriate things he said. And now I don't think they went anywhere, but even though he's worth $1 billion, he only has about $5 million in his name, like less than 5% of his total net worth is in his name. And so that would be the most they would have been able to get at by doing it that way. So it kind of depends on where you're at and what you're doing. Like if you're in a dangerous job, then you may want to protect your assets from you. But most of the time we're trying to protect you and your other assets from that asset.
So say I don't have a rental property, and I have a trust. Would you still recommend a personal property like your primary residence be in an LLC, even if you don't have other real property?
No, because the LLC only protects you from the asset. And so if someone slips and falls at your house is still for sale, but that like they're still going to take your house, but it doesn't really protect you anything else. So I generally with your primary home, we don't do that because the liability is pretty low. Most people have homeowners insurance as well. So you're already protecting things with that homeowners. So obviously it depends. Generally, if I'm worried about that, the next best thing is like an umbrella insurance policy before I would start doing LLCs. Every LLC has tax ramifications as well. How you set them up, you're filing taxes and your accountant's charging you a couple $100 a year to do it. And so everything has a cost, right? And I'm a spend as little as possible for the most realistic protection. I had to learn that the hard way. I set up a bunch of LLCs when I was first an attorney because I'm like, oh, I can do this. And then my accountant hit me with like a $1,500 tax bill and told me, he's like, hey, you don't need these 3 other LLCs. If we get rid of them, your tax bill would have been $500. And I'm like, oh, and we got rid of them. So I had to learn the hard way that just because it makes sense from a legal standpoint, there's other ramifications like taxes and those types of things that need to be taken into consideration. So from an estate planning standpoint, there's no tax ramifications for doing a revocable living trust. So there's literally no downside to doing an estate plan like that we talked about today. Then as you get into these other things, we just want to evaluate and make sure it makes sense. Bill, I see you have a question.
Yeah, yes, sir. I think Shannon alluded to this fact before, but if you set up a trust and you have many kids, we have 6. In order for it to get properly distributed afterwards, should you put all the kids on the trust? We just have somebody executes it or what?
Yeah, all of the kids will be a beneficiary of the trust, assuming you want them to receive something. If one of your kids is mean, then you don't have to give them something. But I don't suggest that they have to make decisions together. And the biggest reason is that's not the time of life where you want them to be communicating about what dad's wishes was. Every kid has a different relationship with their parent, and it's not better or worse, but the memories that I have with my dad are way different than the memories my sister has with my dad. And so we are going to disagree on what dad wants. And so instead of having that conversation, you pick one person to divide it, and then it gets rid of that fight. Almost every fight and every bad, like damaging of relationship amongst kids that I see after a parent's passed away is because they're trying to make decisions together right after their parents have passed away. And so we want to minimize that as much as possible and just have one.
So so all the children become part of the trust, but only one of them has the right to make decisions?
Yes, correct.
Okay.
So like with my parents' estate plan, I'm the trustee because my sister does animals. She has like 50 dogs and she does all that kind of stuff, but money's not her thing. And money and law seems to be my thing, I'd hope, because I do this for a living, right? So my dad made me the trustee, but he made my sister the person who made healthcare decisions because she's a lot more caring person than I am. And I'm calculated and I will run the numbers. And he's like, no, your sister will not pull the plug for a lot longer than you will, Chris. And but what it really did there is now we each have a responsibility, right? It's not that he loves me more or he loves my sister more. It's I'm doing these jobs, she's doing those jobs, and everyone feels taken care of. And we'll do the same thing. Even if you have 6 kids, we can divide it up so each kid's doing different things, but no kid has to make a decision together.
Okay. All right. That's great.
Catherine asked, can you remind us the difference between a revocable and irrevocable trust? Good question. Revocable trusts are what we're doing here. And it's exactly what it sounds like. You can take it back. So you can put things in and you can take it out whenever you want. So you can put your house in there, and 10 years later, you decide to sell your house and buy a new house, you can do that. You don't need my permission. You don't need the court's permission. You just do whatever you want. Irrevocable is exactly what it sounds like. You can't take it back. When you put something in there, it has to stay in there. The advantage to that is like the tax planning things, right? That crazy cabin in Bear Lake that I talked about, that was an irrevocable trust. The dad put it in there. Dad was not allowed to be the trustee. The person who puts things in is not allowed to be the trustee. Someone else is. And they're only allowed to do what's with that trust, what's being said to be done in that trust. The reason you would do that is for tax planning or Medicaid planning. To qualify for some of the Medicaid and Medicare benefits, you can only have so many assets. And so what you do is you put your assets in an irrevocable trust at least 5 years before you need the Medicaid or Medicare. And then they don't count towards your assets. Those are, so they're we call them Medicaid trust pretty much. But the downside to those is after you pass away, the government gets first dibs at what's left over in that trust. And so we can do them for people with disabilities as well, right? So if you had a kid with some sort of disability and they're receiving government benefits, if they have it's only like $3,000. It's not very much money before they lose all of their government benefits. And so you don't want to give them any share of your trust, or they lose all their government benefits and they'll burn through their money in a heartbeat. So you would put their assets in their share in an irrevocable trust. So it's not theirs. A different sibling would be in charge of it. And then they could use that money for that kid's benefit. So if the kid wants to go to Disneyland, you could buy Disneyland tickets. You can give them Disneyland tickets or a cruise or anything like that. But you've got to have a strategy on how to spend that money before the person passes away. Because when the person passes away, the government gets first dibs, and they will want payback for all of the government assistance that they gave. So it pretty much means when the person passes away, all of the money's gone. I've never seen the government not take it all. The government bill is always like $500,000, and you're like, oh, like, and then now no one has to pay it if there's not money in the trust, but they almost always go away. So, but if you have like someone trying to sell you on some of these things, that's why I say they're very unique niches and when you need them. But if someone's just saying like, hey, you know, irrevocable trust is cooler, there's also tax ramifications. You have to file taxes on irrevocable trust. So you're hit with a $250 bill every year. So that's why I put it out there. Like, don't get suckered into that stuff unless you fit into the very unique niche in which you need it. Good question. Any other questions? Sweet. Well, Ethan already put the thing up here, right? Most of these trust-based plans are going to be between $1,500 and $2,000. Funny enough, we actually just raised our rate to $2,000, but the discount's the same. So for anytime I do things like this, like I want to encourage people to do estate plans. And so like any of my past divorce clients, I give a discount. Anytime I meet people like Shannon, I'm like, hey, Shannon, like if your clients want one, I will give your clients a discount. And I always do those for $1,000. So the end price is the same of $1,000. The base price is just $2,000 now instead of $1,500, funny enough. So it's a bigger discount, but the end of the thing's the same. And I did that because there are other attorneys in the Valley that do will-based plans for $995. I'm like, well, and you get all the other things. You get the will, you get the power of attorney, you get that stuff. But then they tag on a big fee for the trust. And I so badly don't want people to just do will-based plans because it doesn't avoid probate, the biggest cost that we're trying to avoid. If you're going to spend any amount of money, it should be to save money somewhere else, right? It either better make it more convenient or save you money. And because I know that a will-based plan doesn't save you the money of the probate, and that's your biggest potential cost, I started doing it for this. To be honest, a lot of attorneys will do will-based plans at a low cost. I've seen some even do it for like $500, and it's a loss leader. It's like the grocery store putting milk at the back of the store. They're doing it to get you in the door, and then at the bottom of every single document it says prepared by Chris Guymon. And what they're trying to do is get your kids to hire them for the probate. And so they do a low cost will, and then they make $5,000, $10,000, $15,000 on the back end on probate. I don't do probate. So I am not doing this as a loss leader because I will not do that. My entire goal is that you don't ever have to do a probate. But even if you do that, it's more simple. And it's just, this is my passion project so that people don't fight like my parents did.
Mm. I have a question.
Yeah.
So education is great. Action is better. So I don't know where everyone is actually on their journey of getting all of this in order, but say we don't have anything. Say we own our own home, it's in our own name. What would be our first action step to get the ball rolling?
Yeah, I mean, the first thing I always tell people is take your kids' names off of your bank accounts and get your name off of your parents' bank accounts. That's a simple thing. It doesn't cost any money. And I see nightmare after nightmare where that happens. Even when it's innocent things like you go pick up your parents' groceries for them and you put your prescription on there as well. And that's a big problem. It's technically legal, but it causes some serious concerns when it's found later. So that's a big one. The biggest thing though, like if you have any of those three things, if you have kids, if you have real property, or if you have a net worth of at least 50,000, if not 250, would be make this a priority. This won't take very long. The questionnaire to fill out is maybe 30 minutes, and then the signing appointment is maybe 30 minutes. So we could get you done in maybe an hour of your time. Like it would be very little time. I've tried to make the estate planning process as simple as possible because the average person decides they need an estate plan and they don't get one for 6 to 9 months. Because it's never urgent. And then time and time again, Prince died without an estate plan. Michael Jackson died without an estate plan. Even these big people, Michael Jackson died with $50 million in debt. His net worth was a negative 50 million and he had no estate plan. So he lived, I don't know how you live life on 50 million of other people's dollars, but Prince had a quite big estate and not surprisingly, tons of people came out of the woodwork saying that Prince was their father and wanted a piece of his estate planning pie. So it happens to a lot of prominent people and stuff. It's just so easy. I would just make it a priority. Just do it before it becomes a problem because it's so simple, but it can save so much time and so much money if you're willing to invest an hour of your time.
I have a little bit of guilt. It's something we just need to get done, right?
Yeah.
Ethan, if you'll do the next slide, you can see how you can reach him. If you're interested in having him help you, if you have additional questions, if you have additional questions, we do not have to end right now. I just wanted to throw that out. Yeah, raise your hand, unmute, ask any questions while we've got them.
And I do free consultations at the office as well. So if you have like a couple of questions and want to ask, like feel free to call the number there on the slide and we can set you up with a free consult to ask your specific questions if you don't want to ask it in front of the group. Like I said, this is my passion project. My income comes from a lot of other things at a much better hourly rate than this is. But I'm pretty passionate about it because, like I said, I've told crazy stories of my grandma had Alzheimer's. My grandpa on the other side had Parkinson's disease. My grandma, my wife's grandma had the crazy things. My dad didn't talk to any of his siblings. My mother-in-law didn't talk to any of her siblings. Like I've had so many crazy nightmares when it came to estate planning, and they're so easy to avoid. It really is. I mean, it's $1,000. It's not nothing, but it really is an hour to an hour and a half of your time, and it just avoids so much.
So I have a question for my parents.
Yeah.
So they have 4 kids and 2 of us are trustees to make a decision, but we have to agree. What is your thought on that? Like I've gone back and forth on my opinion on that because I think, well, I might not agree with him and he might not agree with me, and that's a problem.
Yeah. And if you can't agree, then you end up doing a probate action to figure out who's
Anyway.
wins. And that's why I don't like it. I'd rather just one person get to pick and everybody realize, okay, mom and dad didn't want us to fight, and it's less important about the money and it's more important that we get along. And so now, do I do dual trustees on people's trust all the time? Yes. If you want a dual trustee, I'm going to do it for you. I'm going to give you the same lecture I just gave you today on why you shouldn't. But at the end of the day, it's your estate plan. If that's what you want to do, we can. And some people do get along great. And so, and there's reasons sometimes with powers of attorney, we often will do multiple people, especially like healthcare ones. We can say anybody can make a decision. And that way, if you're available, you get to make the decision. But if you're in New Orleans and your sister's available, she gets to make the decision, right? So there's a lot of flexibility on that kind of stuff. But generally speaking, my vote is always, let's not make your kids make decisions together during that sensitive time.
And I actually have 5. There's 5 kids. I said 4.
I'm not going to ask which sibling you forgot, so that's
Oh,
fair.
the one that's on there with me.
There we go. Good. Any last questions?
Uh,
Brent unmuted. There you go. Go for it, Brent.
Okay, so, gosh, I forgot what my question was. Oh, okay, so you do the trust for $1,000, and then how much extra does it cost to put like a durable and a medical POA in there?
That's everything. The
Oh,
will, the
that's in
trust,
there?
the powers of attorney, all of those things on that slide that I said you need, that's all included in the 1,000. The only way it would be more than
okay.
that is if you have like crazy unique ways that you want to divide it. Like if you want to give your assets to people over time, then we have to do some customization that there's extra costs there. But if you're just standard, give your kids whatever percentage you want them to have, all of those documents are included in the fee.
Okay, give it to our dog, that would cost extra.
Yeah.
I'm kidding, I'm kidding. Okay, all right, that's awesome, thank you.
Yeah, you bet.
And your recommendation is you're never too young to get this going, as long as you fall within one of those 3 things.
Mm-hmm. Yep. Yeah. You know Dakota Bodley? He's an agent. He was like baby faced when he first started. He looked like he was 12, and he was married and he had his first kid. And we did one for him. And I mean, like I said, he looked like he was 12. He by far looked like the youngest person I'd ever done one for. But yeah, I mean, he's been so grateful for having that over the years as weird things have come up. And yeah, there's no downside to having it. And there's no maintenance fees or anything like that, right? For other people, like when you're doing those ones where you're doing maintenance fees and all those types of things, then maybe you consider whether or not it makes sense. But at a low cost and no maintenance costs, there's really no reason not to.
That brought up one more thing. How often should you review it? And where there's no maintenance, are we the ones responsible then to just review it?
Mm-hmm.
I mean, do we
I
need to come
send
back to you for
reminder
a-
emails to people to review their stuff. I usually suggest just every couple years checking, and like what you do is you go through the funding instructions that I'll give you, and it says like bank accounts, and you kind of ask yourself, have I had any changes in my bank accounts? If you have, make sure it's right. And it tells you exactly what to do there. So you just kind of run through those funding instructions every once in a while. Funny enough, I was doing this one time for somebody, and I had a Fidelity account that I'd opened. And at first I opened it and it had like $100 in there. And then the next thing you know, I had like $20,000 in there. And I was like, oh, like I should probably set up the death beneficiary on that. So even I, the teacher of this stuff, has to review my estate plan every once in a while and make sure it's funded properly. I see a hand, Brent.
Okay, so just for clarification, the current home that we have, if we put that in the trust and we sell it later and we buy another one, then do we do an addendum to this trust, or do we have to do a whole new trust?
No, you don't actually have to change anything with the trust. All you do, it's on the title side of things. When you buy the next house, the owner of the next house will be you and your spouse as trustees of the trust. And that's why you want, like, this is my pitch for Shannon here. This is why you want a good real estate agent. Like, Shannon's not stupid. She's really smart. So if she sees that your house is in a trust and she helps you buy another house, she's going to say, hey, don't you want to put your new house in a trust? And then the title company will do it, and it's really easy and it doesn't cost you anything, right?
Okay, so
what happens is sometimes agents aren't paying attention and they don't say that. And then you buy another house and you put it in your own names. And then it's only a couple $100 to put it in the trust. but it's still a couple $100 of an annoyance of, man, if we just paid attention the first time, we
It's
wouldn't have.
another deed. And our other realtors on here, Catherine and Vicky and Ethan, same. Like they
Yeah.
know this stuff. We train on this stuff. Yeah, it's good. You're in good hands. So.
Absolutely.
Okay, so it would just roll into everything else is still in the trust, what, your toys, whatever you got.
Mm-hmm.
Those still in your new house, you pay the title company to put it in that same trust. So everything stays, okay.
Mm-hmm. Yeah,
All
it's
right.
just an empty vessel, so you can put things in and take it out however you want.
Okay.
And the only time you would have to pay me to change something is if you changed who's getting what or who's in charge of what, right?
Okay.
So if you made your oldest kid the trustee and then your oldest kid starts doing drugs and you decide they don't want to be the trustee, then you'd have to pay me to change that. And that's usually like $100. It's not a whole lot of money, but
okay, so we're both the trustees of our trust right now. If we did that, if one of us passes away, it automatically goes to the other one. We don't have to do any
Yep, that's already built
okay.
in, so you don't have to do anything there.
Okay.
And then you'll already have a successor trustee picked out. So when both of you pass away, it'll automatically go to that successor trustee. The only thing we'll need is a death certificate to prove that both of you have passed away for that to automatically kick in, but there's no fee to it.
Okay. All right. Thank you.
Yeah, I try to think of all of the potential situations that will happen. Like we usually have a couple successor trustees in case, a kid predeceases you. I don't always get it. Like I just did one the other day for a good friend whose oldest kid started doing drugs and they needed to pull him off of the trustee. So I can't preempt every possible scenario, but for the most part, we try to think of it so you're not coming back. Good. Catherine.
Thinking about it from a real estate side, obviously, as agents, we have standard contracts that we use to purchase a home, sell a home, all those things. As an attorney, do you guys specifically within your firm have documentation for estate planning, and then each firm has their own documentation, or is there a standard state documentation to build an estate? Because it sounds like you're saying that you've customized your estate planning, which is awesome. So it sounds like it's specific to you. Is that correct?
Yeah, that's correct. There's no state standard form for this. And so, yeah, each law firm's going to have their own rendition of this. And I worked with it's a company called Wealth Counsel, and they teach all 50 states. That's how I know my estate plan is good in all 50 states, is because it's been designed to be that way. Even though I can't advise and say that officially, I know it works because it works. I also worked with the in-house counsel for Intermountain Healthcare with my powers of attorney, and I reviewed those with them to make sure that they would be okay. Because Intermountain Healthcare is most of the hospitals in the state. They're not all of them. The specialty hospital or whatever they call themselves now, they like change their name like every 2 years. It's not them, but 95% of the doctors in the state are under the Intermountain Healthcare umbrella. And so I worked with their in-house counsel as well to make sure my powers of attorney work for them. So yeah, I've spent way more hours than I want to admit on my template to make sure it works. Good. Awesome. Well, I don't want to keep you guys forever. I'm always happy to answer questions. I can talk about this stuff all day, but I want to respect your guys' time too. So if there's no more questions, oh, Bill has a question. I knew if I said that, someone would have a question. Go for it, Bill.
Yeah, it's just a dumb question. If you're a couple, you just have one trust and it covers both of you and whatever circumstances happen.
Yes, that's the short answer. Some estate planning attorneys will do AB trusts. So each of you have your own trusts and it transfers. The reason for that is kind of like complicated on what happens if you die and remarry and all those types of things. We address most of those things in our trust. It does require a little bit of trust in your spouse to do it this way, but it's a lot simpler and doesn't require transferring. Like if you do an AB trust, not the way I do it, then the house only goes into one of your guys' trusts. And so it kind of becomes tricky with that kind of stuff. Especially with divorce, if it's in one person's trust and not the other. I've seen them sell it while the divorce is pending and it'd be a problem. So I suggest just having one trust for both of you.
Okay, that's what I wanted to know.
Yeah.
Thank you.
Absolutely. That way is better in divorce situations, having one trust. But it's a little weird if you die early and your spouse gets remarried. They could technically pull it out of the trust and give it to their new spouse. So it's not, there's no perfect situation anywhere, but I found this to be the most usable, generally speaking.
Love it.
Sweet.
Great. So much good information. Thank you so much for coming and being
Yeah.
on, sweats and all.
You never got to see the sweats. I hid them the whole time.
Yeah, thank you all for joining. It has been great. What a great wealth of knowledge. So definitely reach out. I'll be reaching out myself. And yeah, thank you. Thank you so much. We'll tap out. Everyone have a great night.
You bet. Thank you. It's good to see y'all.
Bye all.